name is Tracey Diamond, and I am of counsel with Pepper Hamilton and a member of the Labor and Employment Practice Group in Philadelphia. Thank you for joining us today to discuss bringing employees back to work. I am joined by three panelists: Susan Lessack, a labor and employment partner at Pepper Hamilton, resident in our Berwyn, Pennsylvania office; Lee Tankle, associate in our labor and employment group, residing in our Philadelphia office; and Kristalyn Lee, associate with Troutman Sanders, located in Orange County, California. We have broken down the back to work issues into three parts: workplace safety, issues resulting from an employee's illness or exposure to COVID-19, and issues concerning employee complaints centered around COVID-19 and the employer's responses to COVID-19. Turning to workplace safety issues first, we will start with Lee Tankle. Lee, as businesses look forward to reopening, what protocols should they be putting in place to protect workers from exposure to COVID-19?
Good question, Tracy, and something that we are talking about a lot. The list of protocols is long and ever-changing, but I want to provide as many tips as possible in the short period of time we have today with our listeners. These tips are in no particular order of importance. And again, I cannot emphasize the ever-changing part enough. You may recall when we did our first COVID-19 webinar in the beginning of March, the CDC was advising that non-healthcare workers did not need masks. Well, look, here we are 2 months later, and now federal health authorities are recommending that all individuals wear a mask in public, and many cities and states are requiring it. So, what we say today may not be true in July. So, what protocols should businesses have in place? Delay reopening. If working remotely and from home, working out for your workforce, continue to do it for a period of time, even after stay-at-home orders are lifted. It's the best way to ensure the safety of your employees, and you'll be helping society by cutting down on the use of public transportation, daycares, and other resources as we reopen our. But we recognize that might not be possible for all employees. So the next protocol you can consider is determining what type of protective equipment you need and where you will get it from. Determine what type of protective equipment you need and where you will get it from. If you are in a jurisdiction where face masks are required, your employees likely already have their own mask. In some jurisdictions, including New York and Pennsylvania, employers are required to provide face masks, although employees are permitted to use their own masks. While these supplies are becoming more and more available, I saw my local pharmacy has boxes and boxes of reusable face masks today. You want to make sure that you have a steady amount of these supplies as you begin to reopen your workplaces. Another common thing that we're advising many employers to do is to issue questionnaires to employees before they come back to the workplace for the first time, and then continue to do so on a daily basis. Ask questions about COVID-19 symptoms or interactions or close contacts with individuals with COVID-19 or individuals who have symptoms of the COVID-19 disease. If employees indicate they have symptoms or they've had close contact with others with COVID-19, don't let them in the workplace and send them home. You want to make sure that you also have a protocol for screening sick employees. After we return to work, it is inevitable that there's going to be flare-ups in different pockets of the country, and employees will unfortunately continue to become ill with COVID-19. In order to prevent another large outbreak like we're currently experiencing, and to protect the employees in your workforce, companies should have a comprehensive list of questions that it asks of any employee that calls in sick for the foreseeable future. For example, employers should definitely be asking employees who call in sick if they're experiencing any COVID-19 symptoms, such as fever, chills, cough, shortness of breath, and loss of smell or taste. If they are, you want to make sure those employees stay out of work for a period of time that complies with the ever-changing CDC. It's important that you do not discriminate against older workers or workers with pre-existing medical conditions. As most people know, older people and people with certain pre-existing medical conditions, such as diabetes and high blood pressure, have a higher risk of severe illness if they get COVID-19. Employers cannot categorically prohibit these individuals from the workplace. What can you do with older employees or employees with pre-existing medical conditions? First, and only if they ask, you should consider providing them with a reasonable accommodation and treat it like any other request for an accommodation, just like what you would a few months ago. Second, keep in mind you cannot exclude an employee unless it is crystal clear that the employee's disability poses a direct threat to the health of an employee that cannot be eliminated by a reasonable accommodation. The term direct threat is a legal term of art, and it requires an employer to show that the individual has a disability that poses a significant risk of substantial harm to the employee's own health. Merely having a condition on the CDC's list of complicating disabilities like diabetes or high blood pressure does not create a direct threat. Rather, an employer must conduct an individualized assessment of each situation. If you're considering excluding an employee from the workplace due to their medical condition or disability, even if you're doing so because you want to do everything you can to protect your employees, I strongly advise that you consult with an employment attorney to fully assess the situation so that you can make sure you don't end up with a disability discrimination. One that may be obvious to many employers, but that they may not know how to implement. It's important for employers to observe infection control practices and make sure that you are doing proper cleaning. To the greatest extent possible, you want to ensure social distancing in your workplaces. Require regular hand washing, have hand sanitizer and other disinfecting cleaning supplies readily available for employees. As of today, OSHA has not issued mandatory COVID-19 workplace cleanliness rules. Certain states and cities have issued such guidance for essential businesses. While OSHA has not issued mandatory COVID-19 workplace rules, they recently issued non-mandatory guidance for employers in certain industries, including construction, manufacturing, restaurants, retail, and meat and poultry packing. Employers in the aforementioned industries would be extremely wise to review and apply these recommendations. Those not in these industries also consult that guidance for ideas about implementing infection control practices in your workplace. What are some of the highlights of this guidance for specific industries? Of note to me, keeping in-person meetings as short as possible, limiting attendees, and applying social distance. Keep in-person meetings as short as possible, limit attendees, and apply social distancing rules. That generally means if you're going to have a meeting, keep it as small as possible and make sure everybody's at least 6 feet apart. Establish flexible work hours or stagger shifts to prevent all of your employees from entering and exiting at the same time. Don't share any tools or equipment without disinfecting them between use. Coordinate with any housekeeping staff to ensure they're properly disinfecting. And in addition to the federal guidelines about reopening, pay attention to what your state and local governments are ordering. Many state orders impact back to business protocols. For example, as of today, Pennsylvania has issued specific guidance for the construction industry that requires all employees to wear face masks or face coverings. And they also need to employ job site screening, meaning that they need to give questionnaires and temperature checks to determine if an employee is able to work. Michigan is requiring certain businesses, including food serving establishments and manufacturing facilities, to require that masks be worn in the workplace. And Michigan construction employers are required to conduct daily entry screenings, including a questionnaire and temperature checks. Those are just what 2 states are doing. Many states all across the country are implementing these rules as well. Some other things you might need to be doing: modify your physical workplace. You have employee break rooms or cafeterias. You may need to close some of them, at least temporarily. You're in a call center-like environment with employees sitting at desks right next to each other. You want to make sure you take steps to ensure that employees are at least 6 feet from each other at all times. If you're in a skyscraper with heavily used elevators, you'll want to make sure that you have some sort of protocols in place to limit the number of individuals who go in an elevator at any one time. And if you have employees using common refrigerators and microwaves, consider instituting rules about who is allowed to use these items and proper cleaning of these items after each use. And then, of course, keep following the news, keep visiting the Pepper Hamilton and Troutman Sanders COVID-19 resources. Consult with labor and employment attorneys before you make any major decisions, because OSHA, CDC, state and city governments are constantly issuing new guidelines and requirements.
Lee, you mentioned that some states and local jurisdictions require employers to check employee temperatures. What about in states or industries where that hasn't been required yet? Are employers allowed to check employee temperatures? And can employers require employees to submit to testing for the virus and or antibody testing?
Sure. Good questions, Tracy. I'll start with are employers able to check employee temperatures? Answer to that question is right now, yes. Employee temperature checks are considered medical examinations, and generally employers can only conduct employee medical examinations if the exams are, quote, job-related and consistent with business necessity. This means in normal times, an employer usually cannot take an employee's temperature. However, the EEOC has said that temperature checks are now permitted at all employers nationwide because of the COVID-19 global pandemic and widespread community transmission. As such, if you choose to conduct temperature checks, you should not allow anybody with a fever, generally a body temperature of more than 100.4 degrees, into your workplace. And if you're going to implement a temperature taking program, consider who's going to take the temperature. Is it going to be one of your employees, or will you utilize a third-party screening company? Where in your building or work site will they do it? What type of equipment do you need to read temperatures, and what type of protective equipment will the person taking the temperature need to wear? And what will you do if an employee refuses to take a temperature test before entering the workplace? Now, Tracy, your second question was, can employers require employees to submit to virus testing or antibody? First, with regards to virus testing, an employer may choose to administer COVID-19 before they enter the workplace to determine if they have the virus. But as many Americans know, the difficulty is actually gaining access to reliable and fast COVID-19 tests. But when and if these tests become widely available, the EEOC has made it clear that employers will be able to use them. If your company does come into possession of any COVID-19 tests, you should make sure that the tests are accurate, reliable, and comply with FDA guidelines. And you should also be aware that there are obvious limitations to testing, at least right now, because an employee can test negative for COVID-19 on Monday, but then test positive the very next day on Tuesday. You also asked about antibody testing, something we're hearing about a lot in the news, but the EEOC has stayed silent about antibody testing. So at this point, it's reasonable to assume that they have not signed off and approved of antibody testing, but we should stay tuned on that front, and employers would probably be wise to not antibody test without fully analyzing the implications and consulting with attorneys. However, even if at some point government authorities make clear that mandatory antibody testing is permitted, the science is still unclear. It's unclear whether having COVID-19 antibodies does mean you're immune from COVID-19. And many manufacturers of these tests are warning against their limited reliability. Unfortunately, at least at this point in time, antibody tests are not a magic elixir that can serve as a litmus. At least at this point in time, antibody tests are not a magic elixir that can serve as a litmus test of who can come back to work.
Thanks, Lee. For issues related to employee illness and employee exposure, we turn to Susan Lessack. Susan, how should an employer handle a situation where an employee is sick in the workplace? What about employees who are exposed to the virus either at work or outside of work?
Thanks, Tracy. If an employee exhibits COVID-19 symptoms in the workplace, the employer should immediately isolate the employee and then send the employee home. Before doing that, the employer should ask the employee to identify all other employees or other people who have worked in close proximity to the symptomatic employee during the 48 hours before the onset of the employee's symptoms. And close proximity is generally understood to mean within 6 feet for at least 10 minutes. The employer should notify the employees who came into close contact with the symptomatic employee that they may have been exposed to the virus but should not name the employee. That's considered confidential medical information that the employer is not entitled to share. The sick employee who is sent home should stay there in accordance with CDC guidelines. As Lee mentioned, those guidelines have been evolving as the CDC learns more about the virus. A couple weeks ago, they provided that an employee should not return to work for 7 days after the onset of symptoms. The CDC has revised its guidelines so that they now provide that employees who are sick with COVID-19 should not return to work for 10 days after the onset of symptoms, and then only if they've been fever-free for 72 hours without medication, and if their respiratory symptoms have improved. It's important to also check any state or local orders which may have additional requirements regarding return to work. The other thing to keep in mind, as Lee mentioned, is after the sick employee is sent home, the employer should clean the office in which the employee worked or the facility and any common areas that the employee used. The CDC recommends waiting 24 hours to do that cleaning if possible. You also asked how an employer should handle the situation where an employee was exposed to the virus, either in the workplace or outside. If the exposed employee does not have symptoms and is not a critical infrastructure employee, the employer should send the employee home to quarantine for 14 days. If the employee does not develop symptoms during those 14 days, he or she can return to the workplace. However, if an employee is a critical infrastructure employee, and that would be an employee who works for one of the essential or life-sustaining or critical infrastructure businesses that have been allowed in various states to remain operating during this time, that type of exposed employee does not, according to the CDC, does not have to quarantine. They can continue to report to work as long as the employer takes certain precautions. Precautions include taking the employee's temperature and screening for symptoms every day before the employee enters the workplace, instructing the employee to self-monitor for symptoms and to alert the employer if the employee develops symptoms, directing the employee to wear a face mask for 14 days after exposure, instructing the employee to practice social distancing, and regularly cleaning the employee's work area and any shared area. And finally, if the exposed employee develops symptoms or tests positive, the employer should treat him or her the same as if the employee was in the workplace and developed symptoms. The employee should self-isolate and can return to work in accordance with the CDC guidelines that I mentioned earlier.
So if an employee does need to be out of work because of a COVID-19 related illness or some other COVID-19 reason, what laws do employers need to follow in granting an employee a leave of absence?
Well, there are a few different laws that might apply. The first is a new law that Congress passed in response to the pandemic, and it went into effect on April 1. It's called the Families First Coronavirus Response Act, and it includes two laws that provide for paid leave. Both of those laws apply only to employers with fewer than 500 employees. The first type of paid leave is under the Emergency Paid Sick Leave Act. Under that act, an employee is entitled to up to 80 hours of paid leave if the employee is unable to work either at the workplace or remotely for one of the following reasons. One, the employee is quarantined because of a government order. 2, the employee is quarantined on the advice of a healthcare provider. 3, the employee is caring for an immediate family member or household member who is quarantined because of a government order or on the advice of a healthcare provider. 4, the employee has symptoms of COVID-19 and is seeking a medical diagnosis. Or 5, the employee is caring for his or her child whose school or daycare is closed or whose child care provider is unavailable. If any of those situations arise, the employee is entitled to up to 80 hours of paid leave. The amount of pay depends on the reason for the leave. If the leave is for the employee's own quarantine or because the employee has COVID-19 symptoms and is seeking a diagnosis, the employee will receive his or her regular pay up to a maximum of $511 per day or $5,110 in total. If the leave is to care for someone else who is quarantined or for a child, the employee will receive 2/3 of his or her regular pay up to a maximum of $200 a day or $2,000 in total. The second type of paid leave under the Families First Coronavirus Response Act is under the Emergency Family and Medical Leave Expansion Act. This type of leave is available only to employees who have been employed for at least 30 days and who are unable to work either at the workplace or remotely because they have a child whose school or daycare has closed or whose child care provider is unavailable and they need to care for that child. If an employee needs leave to care for a child whose school or daycare has closed or whose child care provider is unavailable, the first 80 hours will be paid under the Emergency Paid Sick Leave Act that I mentioned earlier. After the first 80 hours, the employee is eligible for up to 10 weeks of FMLA under the Emergency Family and Medical Leave Expansion Act. Emergency FMLA will be paid at 2/3 of the employee's regular pay, up to a maximum of $200 per day or $10,000 total if the employee takes the entire 10 weeks. In addition to the two types of leave available under the Families First Coronavirus Response Act, if an employee or an employee's immediate family member becomes sick with COVID-19, the employee is probably also eligible for leave under the regular Family and Medical Leave Act because of a serious health condition. Regular FMLA would apply only if the threshold requirements for receiving FMLA are met. Those are that the employer has at least 50 employees, the employee has worked for at least 1 year for the employer, and has worked 1,250 hours in the preceding 12 months. If those threshold requirements are met, an employee is entitled to up to 12 weeks of unpaid FMLA. The 12 weeks encompasses both leave under regular FMLA and leave under the Emergency Family and Medical Leave Expansion Act. In addition to the new law and the FMLA, some states and municipalities have paid sick leave laws that might apply. Some of those laws, like those recently passed in New York and in certain cities in California, apply specifically to leave taken for COVID-19 reasons. Others provide leave for illnesses of a family member or the employee himself or herself, and those might apply if the employee or a family member becomes sick with COVID-19. And finally, employers should determine whether employees who need to take time off for COVID-19 related reasons are entitled to paid time off under their company policies.
Thanks very much, Susan. We're going to turn now to Kristalyn Lee to discuss issues related to employee complaints in the workplace. Kristalyn, what laws are in place to protect workers who complain about workplace safety issues?
That's a great question, Tracy. As we've seen, the federal and states have taken, far drastic approaches when it comes to dealing with COVID. But the thing that they do both have in common are protections to safeguard employees against potential retaliation if they do complain about workplace safety issues or any other work-related issues for that matter. On the federal front, the Occupational Health and Safety Act, OSHA, also known as OSHA, is more geared towards unsafe working conditions and protects employees from retaliation if they do raise safety concerns in the workplace. As we've seen in the healthcare industry, we've seen a huge uptick in OSHA complaints. I think the most recent numbers were in the thousands in the past month, just with respect to the PPE and the various working conditions. That's also OSHA has been a big issue with respect to the manufacturing plants, like the meat processing. Another federal protection is under the National Labor Relations Act, or NLRA, and that protects concerted activity. And so that would include worker discussions about certain working conditions, which could include, workplace safety. And so in addition to those federal components, on the state level, you'll have to want to monitor your particular state, but typically states will have whistleblower statutes in effect, which are geared towards protecting employees who report, any illegal or wrongful conduct by their employer. But in addition, there are industry-specific regulations like healthcare facilities or other health and safety codes. There's also the traditional general retaliation protections that protects employees from retaliation should they engage in protected activity, which would encompass employee workplace complaints for safety. And then there's also common law wrongful termination claims that are based on these specific statutes that are protecting employees from retaliation. And so that's just a broad overview, but it's going to be also, in addition to the federal components, very state specific as well.
Great. So in light of these laws, how should employers handle workplace complaints?
So I think the first thing will be knowing how to recognize a complaint. And, from what I just described on the potential retaliation claims is that a retaliation claim could be based on something that isn't necessarily a traditional complaint that's being voiced in the workplace. It could encompass taking rights under, the FFCRA or taking FMLA that's related to COVID. And so, the whistleblower complaint is a little clearer cut since the employee is actually blowing the whistle on their employer. But this protected activity that can form the basis for these potential claims can just take place in various shapes and forms. And so, it could be something as ranging from actually voicing that an employee feels unsafe in the workplace, or it could range from just refusing to engage in an unsafe, task or opposing an unsafe practice. Another thing that we've seen too or heard about on the news are, Amazon and some of these other bigger companies are dealing with sick outs. So that could be something that is encompassed under protected activity as well as concerted activity under the NLRA. So another thing that we've been seeing for just the various types of complaints that we've seen are complaints that not necessarily happen during work hours, or they occur off the premises. A lot of media surrounding COVID, and one of the ways that employees can voice themselves is through social media. So, what happens if you find out that one of your employees is on social media and they are creating a page to complain about how, your company has responded to COVID? And that's actually something that we've seen in an actual lawsuit that was filed against Trader Joe's, where an employee had created a private social media Facebook page to voice his complaints about how Trader Joe's had dealt with COVID and the protections or lack thereof that were in place. And the allegations in the complaint state that the Trader Joe's had confronted this employee about his Facebook page with printouts. And a week later, he was terminated. And so, that's one thing that we're seeing, that it's not just limited to the traditional something that's happening in the workplace. Another case that we had, or potential case, that we've seen is a law firm had an employee who made, along those same lines, of a social media post that was threatening in protest to having to wear masks. And this particular employee posted a threatening message referencing his use of his shooting range and using ammunition, and it had a violent connotation. And the firm made the decision to terminate this employee, even though this conduct happened not during work hours, not even in relation to what he had experienced as part of his employment, but just because it was something that he expressed off duty that was in violation of what they perceived to be the firm's values. That's another type of complaint that we may see as well. And so with that, there's a broad range of topics that protected activity can cover, and in addition to workplace safety, but the common ones that we've been hearing about are the lack of PPE, or the certain whether employers are having response plans in place, or employees who aren't wanting to come back to work because, say, for example, they're making more in unemployment, or also an uptick in potential race or national origin discrimination. So it's important to know how to recognize what could qualify or form the basis for a potential retaliation claim, whether it's a complaint that's verbal or could be perceived as protected activity. And the second thing that it's important to handling the employee workplace complaints are training. Because usually these employees aren't going to be going to high-level management. They're going to be going to your workers on the front line. And so it's important to ensure that your managers and the front line are familiar with, potential anti-retaliation policies, handling complaints, and recognizing complaints and escalating it when appropriate. Another thing that's important is encouraging open communication. Do employees, do they feel safe to report these and ask questions and feel that their opinions are valued? We want to give employees avenues to voice their concerns. All of this COVID has hit everyone by storm, and it hit very quickly. And so it's important to have an open dialogue with employees if they have suggestions that they can bring up, and it's a type of culture that the employer is encouraging. Is it one of fear? Is it in transparency? But certain clients that I've seen, they've hosted certain town hall meetings or issued regular updates or newsletters, if you will, and designated a point of contact specifically for COVID-related concerns. And along those same lines is that even though you can encourage open communication, the next step is to investigate if necessary. Because although you can encourage employee communication, that it's one thing to do that, but an employer needs to show that they're taking action to take these complaints seriously by investigating. And so that's one thing, and we would encourage that, just depending on the nature of the investigation, to consult with counsel if that's something that needs to be escalated or involved. Another important tool is to document. So I can speak for California, but these employee complaints we can anticipate that this is going to be the basis for a lot of litigation going forward. And I can barely remember what I had for dinner yesterday. And so it's going to be really difficult to remember something 2 or 3 years down the line when a lawsuit comes up and you're trying to rebuild what happened, how we handled the employee complaint, what they said, how we investigated, and what were the basis that we had to take any adverse employment action if that were the case. And so it's really important to make a documentation of when these complaints are made, any discussions that we had with the employee, a chronology that you can reference back to have a record, because it's very unlikely, like I said, that you're going to remember it, and documentation also is key to help defend against potential lawsuits down the line. And the next step is just to be careful before you're taking adverse employment action. When you think of retaliation and, employee complaints, the first thought that you'll go to is termination. But that's just one example of an adverse employment action. Adverse employment action could be imposing discipline or suspending or furloughing, removing responsibilities, or forcing certain employees to take leave. So just recognizing that it's not to just involve counsel if it's dealing with a termination, just to be mindful that these other types of activities could form the basis potentially for a retaliation suit. It's also really important, we mentioned documenting, but when you're taking adverse employment action, that employers are uniformly enforcing these policies to avoid any potential retaliation claims or even discrimination on the basis of selective enforcement. And it's important to have that objective criteria, preferably documented, to support any significant adverse employment decisions that are going to affect an employee. And I've mentioned it too, but also just checking in with your counsel to guide you through these processes. And that could be whether you choose to open up an investigation or, before terminating or taking other types of potential adverse employment actions, just because these retaliation and claims and employee complaints are going to arise in different avenues, and a lot of these decisions related to COVID have been made in a hurry and under pressure. And so it's important to have legal eyes on something when, employers are already having difficulty dealing with these pre-COVID, but add COVID and all of the new legislation and the potential avenue for employee complaints and corresponding retaliation claims. It's important to involve your counsel when necessary.
Kristalyn, you mentioned a whole bunch of different ways in which employees can complain or may complain. What about the employee who just is plainly scared to come back to work? What can or should an employer do with respect to an employee who's scared to return to work?
Right, and that's a great question. And so employees generally don't have a right to refuse work unless they reasonably believe they're in imminent danger. And so it's going to be, unfortunately, the famous lawyer response of "it depends." It's going to be a pretty fact-specific assessment that should be evaluated on a case-by-case basis. So, we're going to want to see, are there legitimate concerns being raised? Is this, the difference between an employee who's just really trying to milk the system and get paid more off unemployment than returning to work versus someone who is complaining because they've heard that they don't have enough PPE at work, or that they are an employee in a high risk group or has an underlying medical condition that they're going to be coming into regular contact with members of the public. And so it's going to be a different assessment based on how we're going to handle a complaint, whether we investigate that or not. But the next step is just making sure that you're engaging in a dialogue, and communication is key, and discussing those options with the employee, whether it be continued unpaid leave, remote work, or a voluntary transfer to another position that may have less exposure on a temporary basis. But employees also should know too that if they're just trying to kind of make noise and again milk the system and get unemployment benefits because they're making more sitting at home watching Netflix, that if employers are offering them the opportunity to return to work and that employee refuses and there isn't a legitimate justification, that may jeopardize those rights. And so being transparent with your employees if that's the case. And then the next thing to do is, I'd mentioned it before, is investigate it if necessary. If we're dealing with a more generalized fear without anything more, that might not warrant an investigation, but should still be documented if, that employee is raising a concern. But if, we on the other hand, again, have an employee who complains because they're worried about sanitation efforts or other sort of COVID responses, that's something that could warrant an investigation and further action. But the key takeaways are just that, we've seen increases in employment litigation during past recessions, and here we are now dealing with just record-breaking unemployment claims and unprecedented numbers. So we can expect that same increase in litigation. And, although that employers are going to have several strong defense positions based on, unfortunately, mass layoffs or mass furloughs, that plaintiffs' attorneys are going to be looking to scrutinize every employment decision that has been made for any potential errors. And again, many of which employers have had to do in a rush and based on new legislation that continually has guidance that keeps evolving and changing. And so as we've seen in, the potential case with the Trader Joe's that's been filed against them, that there's this already outline and atmosphere for these increase in retaliation and whistleblower claims. So employers should really take steps to ensure that there's the appropriate training and encourage that open dialogue and document and working with counsel when appropriate.
Thanks, Kristalyn. So, an increase in litigation is surely what we're all going to be expecting down the line, and positioning your companies or your workplaces in the best defensive posture possibly is good business. It's good for employees, and it certainly is a good litigation tactic as well. So I hope this answers some of our clients' questions. I want to thank our panelists today. If you have any questions about anything we've discussed today or any other employment questions related to COVID-19 or otherwise, please feel free to contact the labor and employment practice groups of either Troutman Sanders or Pepper Hamilton. Thanks very much.
These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Sanders does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal and other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Sanders.